In law taught already we have finished 8 problems and those problems we have solved. So now we'll go to the ninth problem. And as the ninth problem, a miner had a horse from B for riding. B had expressly told A that the horse was fit for driving only and not jumping. In spite of this, A lent the horse to his friend, and his friend C put it to a fence, and as a result, it fell upon a stake in the fence and was injured. A sets up the defense of being a minor in an action for taught by B. Can he succeed? The facts of the problem have been taken from the leading case, Bernhard versus Hoggies in 1863. In this case, an infant had a mare for riding. He was not fit for jumping, but the infant led the mare to a friend for jumping over the fences, and the mare was killed. In clearing a fence, the court held that there was tort wholly independent of contract for which the infant would be answerable. The act of the infant was a bare trespass, not within the object and purpose of hiring. Therefore, it cannot succeed in the present problem. And now we'll go to the 10th problem. And as the problem A sent a telegram to B for the shipment of goods, the telegraph office mistaking the registered address of C to be that of B delivered the telegram to C. C, acting on it, sent goods to A. A refused to accept them. C sues the telegraph department for his loss. Will C succeed? So, the very fact of the problem are quite similar to those in the case of Dixon versus Reuters Telegraph Company in 1877. In this case, A sent a telegram to B for shipment of certain goods. The telegraph company, mistaking the registered address of C for that of B, delivered the telegram to C. C, acting on the telegraph, sent the goods to A. A refused to accept the goods, stating that he had ordered the goods not from C but from B. C sued the telegraph company for damages for the loss suffered by him, and it was held that she had no cause of action against the company, for the company did not owe any duty of care to she. and no legal right of she could therefore be said to have been infringed. Therefore, in the present problem also, she will not succeed. And now we'll go to the 11th problem, and that is plaintiff's wife having safely crossed in front of an omnibus was startled by another carriage and torn back. The driver had seen her pass and then turn round to speak the conductor. So he did not see her turning back and ran over her. The omnibus was on its right side and going to at a moderate pace. Is the owner liable for the negligence? And if any, so the facts of the problem are from the leading case, Cotton versus Wood of the year 1860. In this case, the plaintiff's wife, having safely crossed in front of an omnibus, was startled by some other carriage and ran back. The driver had seen her pass and then turned round to speak to the conductor so that he did not see her in time to pull off and avoid the mischief. The omnibus was on its right side and going at a moderate pace. Here, there was no evidence of negligence on the part of the defendant, the owner of the omnibus. It was held that the owner of the omnibus was not negligent. Therefore, in our present problem, also the owner is not liable for negligence.